And we have
Am I now with you?
verbally and audio and vision too. So we're getting both.
Thank you.
Two of our senses are operational.
I apologize.
Don't be. I'm just glad we could get everything solved, and we are ready to proceed. Mr. Livesey, let me find my pen. I put it down a moment ago. There it is. Would you like to reserve time for rebuttal?
Yes, Your Honor, if I could reserve maybe 3 minutes.
3 minutes is just fine. I made the notation. Let me stop the clock from running from the other case so you don't start with a deficit time. Okay. We are ready, counsel. You may begin.
Thank you. Thank you, Your Honors. I apologize for the prior problems that I guess it was from my end trying to use 2 different computers. But anyway, we're finally here. To begin with, my name is Stanford Lipsey. I represent J. Stanford Lipsey, PA, which is the appellant in this case. This case really revolves and evolves from a representation of my office of Susie Louder in a child support enforcement action from 2017. She initially came to my office, asked me to represent her based upon a non-payment of child support with her ex-husband. They both resided in Carolina. Arising from that, we spent almost 3 years in discussion over a 1.540 motion, and the ultimate end result was my office, and we obtained a $26,000+, almost $27,000 judgment for an arrearage of the child support that was due her, and enforced that with the payment. During the proceedings of the enforcement was also a modification proceeding, which was filed. That modification proceeding was then continued on after the child support enforcement and after the court ordered payments to Ms. Newhoff of the monies that she was to receive from the arrearage. Well, it comes down to the end of towards the end, and with the matter still pending for the modification, Ms. Newhoff changes counsel from myself to another counsel. It was not opposing counsel, Ms. Lanier, but another one, but a different counsel. I did not just necessarily object. What I indicated was I have no objection in getting off the case. However, I would like for my fees, which at that point in time exceeded over $100,000, to be protected by some form of lien provided by the rules of judicial administration. The court proceeded on not to enforce any type of security interest of my lien, removed me or allowed opposing counsel to be substituted, not this opposing counsel, the other counsel to be substituted. And at the end of the day, Ms. Newhoff and her ex-husband make an agreement. And this agreement provides basically that as she has already received her arrearage payment, now provides that she will dismiss her pending action for modification. He will dismiss his pending action for modification. And Ms. Newhoff will assume all responsibility for all attorney's fees that she's incurred. Well, the problem with that is that since the beginning of the case, Ms. Newhoff, A, didn't have any money to retain me, B, had no funds to match the $200,000 that the husband had spent in avoiding the child support issue. And as a result of it, she's judgment proof. So now where do I stand? I filed a charging lien before I got out of the case and said my services provided her with at least a benefit of $27,000, and for which I'm entitled to a charging lien for that. We filed the charging lien. The court denied or dismissed the charging lien, basically saying that there existed no legal basis to put a charging lien against child support. In the lower court, I had cited to the court the other cases dealing with Tucker and Dyer, and I don't know if I cited the Dimmel case to the lower court because it's a 2020 case, but it's certainly cited in the brief. And what happened is the child support was for the child who had already turned age 18, but the way that the judgment was entered is that all child support for both the minor child and the emancipated child continued until the youngest child reached age 18. So the question is, and that was a question that was on the charging lien, as to whether or not this money was necessary or would, if paid, would deprive a former spouse of daily sustenance, or in this case, deprive the child of daily sustenance, which is what was decided in the Tucker and Dyer case. And we take the position that the court was at least required to make that decision or to make that statement. The court said it didn't find anything that would require it to do it for quote unquote child support. But child support and alimony come under the same exemption, if you will, of a charging lien. But it also does not allow the client, under these circumstances, to enter into the services provided by my office, and then knowing that she is judgment proof, knowing that she has no ability with which to pay, knowing that throughout the entire proceedings in the divorce, in the enforcement action, her primary source was, I need to get my attorney paid. And at the end of the day, I would assert that she basically commits a fraud upon me and a fraud upon the court by entering into an agreement with her ex-husband saying, I will assume all responsibility. That shocks in the face, if you will, of enforcement actions. It shocks in the face of attorneys that are hired for purposes of enforcement and then turn around and say, no, we will obtain funds for you, but then you can just go outside of it. You can discharge me, make an agreement not to pay for opposing party not to pay, which would be contrary again to the my contract, which allowed her, not me individually, but allowed her to seek those attorney's fees. We asked this court, in essence, just to overturn not only the security, that a lien for the security and a security interest should have been perfected and security provided for my fees before I would have been discharged. And secondly, that for her to make that kind of agreement and then just walk away from it without being held responsible under a charging lien is unconscionable. Thank you. Judge, you're muted.
You are absolutely correct.
Thank you.
Thank you both. We are ready for the appellee's response at this time.
May it please the court. Angela Liner on behalf of the appellee, Susan Neuhoff. The issue before the court is simply whether the court's going to abandon the long history of not seeking or not allowing attorneys to seek charging liens against child support. In this case, the only fruits of Mr. Lipsy's labor were related to the recovery of child support. Child support is well established that it's for the benefit of the children, not for the benefit of the parent receiving the child support. And all the case law cited talks about an analysis necessary when the court seeking to enforce a charging lien against an award of alimony. And that is whether it would deprive the party of the basic necessities of life. However, in this case, it's merely child support. That was the only benefit Ms. Neuhoff received during the entire pendency of Mr. Lipsy's representation. Now, what Mr. Lipsy fails to mention in the facts and is very well documented in the record, Mr. Lipsy himself had an error very early on in the case, he created a Scrivener's error in the final judgment that misinterpreted what the child support was pursuant to the parties' marital settlement agreement that was attached to the final judgment. Mr. Lipsey then sought in 2017 contempt based on the improper child support number. There was 3 years of litigation regarding this issue because the former husband was not required to pay the child support number that Mr. Lipsey was attempting to enforce. Ultimately, once Ms. Newhoff became aware of the error created by Mr. Lipsey, his conduct, including 2 appeals that had been filed by Mr. Lipsey at that point that Ms. Newhoff was not aware of, and a civil suit filed by the former husband against Ms. Newhoff and Mr. Lipsey, Ms. Newhoff retained new counsel. New counsel was able to come in and resolve the case. But nowhere in that time did Mr. Lipsey's efforts result in any receipt of any tangible benefit that was for the benefit of Ms. Newhoff. The only thing ever received by Ms. Newhoff was simply child support for the benefit of the children. Now, Mr. Lipsey spends a lot of time discussing the court's failure in 2020 to just secure any interest for the payment of his fees. In his brief, he seems to argue the standard that family law allows to try to put the parties on an equal playing field. So level the finances so that one party with superior assets can't basically roll over the other party. But what he fails to remind the court is that he did file an appeal of that order in 2020. And this court dismissed that appeal as a non-appealable final order. Mr. Lipsey did not seek any sort of certiorari review at that point. He took no actions with regard to that dismissal. It was merely dismissed. Then we fast forward to 2021, to the appeal that's before this court now. Mr. Lipsey asserts that the court failed to make necessary factual findings, failed to consider evidence, or anything of that nature, but he doesn't even produce a record of the transcripts. He didn't acquire a court reporter for the hearing. He doesn't attempt to recreate the record. He simply seeks the court to basically take his word for it that the court failed to do something during a hearing, but without giving this court the benefit of a record to even consider. Based on the lack of existence of a record, I would assert that would be a sufficient basis based on the Applegate case just for this court to not consider any of the arguments raised. But if we get to the merits, the bottom line is Mr. Lipsey presents no authority, as he failed to do in the trial court, that shows how this court can even begin to discuss preserving a charging lien against child support. The closest that we get is one case that addresses undifferentiated family support, but that was a retroactive award of undifferentiated family support at the end of the case. And in that case, the court that basically comes down to, you must determine what is for the benefit of the children and what is for the benefit of the parties. Or I'm sorry, for the parties' basic substantive living, and that's the Jaeger case. Otherwise, and I looked, I can't find a single case in Florida that will enforce child support simply as a charging lien against child support when child support is the only thing awarded. Any analysis that's required by this court about the basic living or what needs are required, all coming from a string of alimony cases, from equitable distribution cases, the Duhamel case, the 2020 case. This issue in that case is that an attorney sought a charging lien at the conclusion of a divorce proceeding. The attorney had only represented the party through a temporary alimony award. and then sought the enforcement of their charging the lien against equitable distribution at the end. Still very different from the case at bar, where the only issue is that child support was received, retroactive child support. Nothing further. I yield my time.
Thank you, counsel. Mr. Livesey, the floor is yours.
Thank you very much. Thank you, Your Honor.
Are we
Yeah,
all on the same page that what is sought is a charging lien on child support?
Yes, it is a charging lien on the child support that was ordered to be paid. And the amount of child support was for the emancipated child over the age of 18 that the husband was ordered to pay in the final judgment, which was a lump sum
Well,
amount.
counsel, here's my question, and it derives from a third district opinion in 2016, with the petitioner's name is Atkins. And they write, more significant is that part of the order directing the father to pay a portion of the guardian ad litem fees directly from his child support obligations. We find this to be error, as child support payments may not be subordinated to attorney fees. And then they list a whole string of citations which basically say a lien is not enforceable against child support payments. A charging lien could not be asserted against an award of undifferentiated family support. Has a case about finding accrued child support becomes vested rights of the payee and not subject to modification. My concern is that there's a large body of law that says we cannot do that which you ask.
And I take that, I understand that position, Your Honor, and that it's not as against the child support, but the question is, and that was the same as I likened it to the other cases of Dyer and Tucker, if it's child support and it's ongoing and it's necessary, as is alimony, that it would deprive the daily sustenance or the daily need of the parent for the money for the purposes of the child. But in this case, the child, one, is over the age of 18. Number two, the child does not live with the mother, and the child was emancipated. And those were the issues that were to be presented to the court. Now, did we have a hearing? No, we didn't have a hearing. What we had was a phone call from the judge, which basically said, and that's why in my brief, there was no hearing and there is no transcript. There was a phone call from the judge that says, this is how I rule. And I asked very specifically, will say that, you know, you're not considering these other cases. And he did not do that. But I understand where the court is, and the court looks at it and says, child support is there for the benefit of the child. Well, if it's there for the benefit of the child, and the mother who enforces the child support in this case has to be the moving party, the child can't be the moving party. So the mother employs the attorney, and as a result of that employment, then the attorney obtains an award. The mother is obligated to pay the attorney. The child cannot be obligated to pay the attorney, but has the attorney created a material benefit, not only for the mother, but also for the child. And this deals with an arrearage, not with a ongoing support, as I believe that case would look at it and say that you cannot charge as against an attorney's fees would not go as against it if it's ongoing support. And I agree with that case, as would be the alimony, because if the alimony is there and is needed for the woman or for the spouse, whichever way it went, you know, to pay the day-to-day expenses, that's fine. I understand that.
Well, it seems that in their string citation, one of the cases entitled Cortina says it finds that the accrued child support or the child support arrears becomes the vested rights of the payee, not subject. It appears to be subject to lien, but I'll reread that opinion in its entirety and not rely on the third district citation of it.
Okay, moving from that, I mean, I still believe in a
I
very
understand the
affirmative.
distinction you're seeking to have us make.
Pardon me?
I understand the distinction you are seeking to have us make.
Right. Well, the other distinction is that, you know, you, in this case, my office provided the services that were rendered, be it with whatever the husband decided to go spend $280,000 on a 1.540, which was decided actually in 2018 by the general master. And he ruled against him in 2018, but he wanted to persist with all this.
I have
And wanted
let
to-
you go on a little bit longer since I took a part of your time, but we're well past 5. You reserved 3, so I figure we pretty much covered it then, counsel.
If the court says I'm through, I'm through.
I'm not through. I think you're going to keep on going.
Oh,
Practicing law. I just think you're out of time
Your
right
Honor.
now.
Okay,
You're not
I
through as an
apologize.
attorney. You're just out of time on this case.
Okay, thank you.
Okay.
Well,
Thank you both.
yeah.
No, we are out of time on this case.
Thank
I
you,
was just
Your
trying to say what you were saying. You're not through as a lawyer, but on this case, we're out of time.
Well, thank you, Your Honor.
Thank you both. That will conclude our session today, and we wish all of you well and good health.
Honor.
Thank you, Your Honor.